Good morning, everyone. The last case coming before the court today is NRA-NP-NP-NPK, and each side will have 15 minutes to present their arguments, and the appellant will reserve up to 5 minutes. If you want to just tell me if you want to reserve time, I'll try to keep time for you.
Thank you.
Thank you.
Good morning, Your Honors. I would like to reserve 5 minutes for rebuttal, if I may. May it please the court, this case involves permanent custody of 3 children that was granted to the Lorraine County Children's Services. This is a case regarding presenting the issue of whether mother substantially completed and remedied the conditions that led to the removal of her children from the home.
Excuse me, I'm sorry. I'm not sure if I missed this, but I didn't hear you introduce yourself. I just want to make sure of my notes.
My name is Kathleen Amerkanian, and I am counsel for appellant mother.
Thank you.
So the first issue is whether mother did substantially complete and rectify the conditions that led to the removal of our children from the home. And we would submit that she did. We would submit that out of all of the concerns that the agency raised, mother really went above and beyond. She completed domestic violence counseling. By the time of the permanent custody trial, there was no issue concerning condition of her home as far as cleanliness, food. She remained employed throughout most of the case. She faithfully engaged in visits with her children. She went through a psychiatric evaluation and assessment, and she showed that there was really no issue concerning alcohol or substance abuse. Where the agency disagrees is on the issue of whether mother complied with their expectations concerning parenting. The agency, as pointed out in their brief, believes that mother's overall presentation and hostility toward the agency somehow bled into the way that she was going to be able to parent the children. As stated in our brief, really the way mother sees it is that her hostility toward the agency, which stemmed from some real deep-seated issues, as she had been molested and beaten as a child in foster care as a youth, had nothing to do with whether she was going to be able to substantially complete that component of her case plan. And in fact, it was partly the agency's decision to combine visits between mother and her children with visits between mother and her grandchild and then another adult child that led to the very chaos that the agency described as occurring during visits. At a certain point, about 6 months after the children went into the care of the agency cut off visits between mother and children. And the reason the agency gave was partly due to an incident where mother called an agency staff member a name because one of her children could not be transported for visitation. There was never any testimony that mother directed any of her hostility toward the children. There was never any testimony that mother verbally abused the children during visits or at any other point during the case plan. It was really a matter of the agency finding mother extremely difficult to work with and mother not really being able to work through all of her issues within the very short period of time that she was given.
Could I back you up for just a moment to the comment that you made about it being the agency who decided to combine the visits with the children and the grandchildren. At the time that the children were removed from the home, the mother had both her minor children, her 3 minor children, and also had care and custody of her grandchildren, correct?
It's clear that mother had care of her 3 grandchildren. I'm not clear on the legal status of those children with her, but From the record, the trial court did find that mother was caring at the time that her minor children were adjudicated. That mother was also attempting to care for the 3 grandchildren.
And
mother
so
tested.
if her children were to be restored to her custody, then presumably she would be in that same situation. And so I guess I'm asking whether or not it was logical for the agency to have the visits with the grandchildren and the children, because that's what she would be dealing with.
Well, Your Honor, I think where I would disagree is whether that was going to be the end result. The 3 grandchildren, I'm aware of one other of those grandchildren having their own case. And so there was a plan to reunify that child with that child's mother. I don't think there was any testimony or any indication from the record that the 3 grandchildren were going to return to mother's home. From the record, it appears that the grandchildren were placed in mother's care on a temporary basis prior to the complaint being filed on her own children. And what happened was, and mother testified that the agency brought her grandchildren to her to live with her sometime around June 2013, I believe.
And then it was after that the grandchild was found wandering.
Yes, the grandchild was found wandering, which led the agency then to come in and look at what was happening in mother's home. And so as part of her case plan, I do not believe that there was any plan for her to get to the point where she would be able to care for all 7 minor children again. In fact, the goal was for her to only be able to show that she can care and parent her minor children. I think that it was, the consensus was that mother was overwhelmed caring for 7 minor children under her roof. And so with respect to, the overall chaos of the visit, really described by one of the caseworkers. And that caseworker, I think it's important to note too, that she was removed from the case or left the case, whatever the case may be, in February 2014. So her observation of how mother was during the visits at the agency was really only between November 2013, February 2014. We also had the testimony of the GAL, who testified that visits went smoothly and testified that mother was braiding her children's hair. His only concern was how the children may act after going back to their foster homes, and in the case of one of the children going back to a residential care facility, which really leads to another separate point, which is that there are certainly many inferences or implications that somehow it was mother's fault that the children displayed some acting out behavioral problems before and after visits. But I would argue that there was no testimony from a mental health professional stating, yes, this was due to mother's behavior at visits. It is just as likely that the children were acting out against having to return to foster care after visiting with mother. Really focusing on what the mother's behavior was at visits. There was nothing to indicate that mother was being inappropriate with the children in terms of verbally abusive or anything like that. The whole crux of the agency's case, I believe, is that mother was hostile toward them, and they didn't like that. They found that very hard to deal with and hard to work with. But when you look at the totality of the circumstances and look at everything that mother had done as part of her case plan, I think it's clear that where the agency was focusing on that one small portion of the pie when you look at everything else that mother was doing, she was on her way. She also testified that there was an anger management component of her case plan. She testified that she began addressing that in her therapy sometime around April. And so she really never had the opportunity to kind of show progress after visits were cut off between her and her children. Whereas the agency caseworker, the second caseworker to come on board, testified that the parenting classes that mother was engaged in did not comply with the case plan. The first caseworker testified that those parenting classes did comply with the case plan. And I don't believe there was any testimony from the second caseworker as far as any specific classes that she directed mother to participate in that would comply with the case plan.
I'm going to interrupt you. Did you say you wanted to save some time?
Yes, I did.
Okay, you've got 4 minutes and 45 seconds. Do you want to, you can go on or you can say?
I would like one more moment just to touch briefly upon the fact that there was part of this case alleged disclosures by the children about abuse. And I think it's clear from the record that all of this was based on inadmissible hearsay. The trial court did not comply with 2151.35F, which has a specific procedure to kind of vet these kinds of disclosures and give due process protections to the parents to be able to address these. These disclosures, these children were not adjudged to be abused. And so while the motion for permanent custody made a general statement such as the agency was investigating these disclosures, there had not been any finding that these children were abused prior to the motion for permanent custody being filed. I think that this goes against what Ohio appellate courts have stated, which is that, you know, the grounds for permanent custody must be in the motion for permanent custody. The trial court, I would argue, clearly relied on these statements as there is mention of the abuse allegations in the trial court's journal entry. I would like to save the rest of the time for rebuttal. Thank you.
May it please the court, my name is Preeti Kishman. I represent Pelley Lorain County Children's Services in this action. The main issue on appeal is whether the trial court's grant of permanent custody of 2MP, 3MP, and 4EK was proper. Under the first assignment of error, the appellant argues that the trial court gave undue weight to mother's hostility towards the agency. As the appellee, we would argue that the trial court gave an appropriate amount of weight to mother's hostility towards the agency. Now, while the lack of cooperation on mother's part was not determinative in terminating her parental rights, it was relevant to whether mother continuously and repeatedly failed to substantially remedy the problems that led to removal. In the case in Ray Brown, the court held that while determining a lack of adequate parental care, courts consider whether a parent's refusal to accept help, follow advice was a precipitating factor in the parent's failure to provide adequate parental care.
But did she really refuse to accept help? I mean, it sounds like from reading the briefs, that she had an attitude and was not easy to deal with. But as the evidence came in, it sounds like she was pretty fully engaged. Did not always, wasn't pleasant. But is this really the kind of case where we want to permanently, sever the relationship?
Your Honor, in mother's case, I believe that she treated the case plan as a checklist that it was just going to therapy, but maybe not engaging and dealing with the issues that led to therapy. On different occasions, for example, with the parenting classes, she wouldn't attend the parenting classes at first. Eventually she did because she knew it was part of the case plan. But in terms of understanding why she needed to take those classes, she continually stated that she felt like she didn't need to attend those classes. She stated to the caseworker that she'd been a parent for 20 years and was more educated than the people teaching the classes and the caseworker. Another issue was that she wouldn't sign releases of information so that Children's Services could to keep track of what kind of progress she was actually making. And on occasions where she did sign them, she would revoke them later, so it made it really difficult for them to work with her. Additionally, she was supposed to work with a parent mentor. I think she met with him for maybe 2 sessions and then decided that she wasn't going to meet with him anymore. And
Was he replaced by another parent mentor?
I don't believe so, Your Honor. She wouldn't give a verification of employment during any of the time that she worked for Children's Services. I believe during the permanent custody trial, she testified and brought in some evidence of employment, but it didn't show that her employment was consistent. Her hostility on its own, that wasn't really the reason, that wasn't an issue on its own, except for how it affected her progress on the case plan, how it affected her visitation with her children. The visits were extremely chaotic. On one occasion, she called the Children's Services supervisor an idiot in front of the children. She didn't, instead of spending those visitations, focus on building a relationship with her children, spending time with her children. She spent that time becoming aggressive and hostile with the caseworkers instead of focusing on what she was there to do. In the appellant's brief, the appellant argues that...
I guess, stopping you on that, I mean, I guess, I'm just thinking that, you know, it's hard to divorce yourself from emotion. And a parent doesn't become an automaton, you know, just, you know, okay, so this is what I'm supposed to do, and I'm not supposed to be worked up because my child wasn't transported, and you know, and I'm supposed to just say, okay, well, I'll just, you know, visit with these other, you know, however many were here, and just go ahead and go along with whatever they're telling me to do. I guess it's just, to me, I'm looking at that, maybe that's a lot, and maybe a little bit too much to expect from somebody. And believe me, we've heard worse name calling than idiot.
Yeah, yes, Your Honor. I mean, I would say that, you know, Children's Services deals with aggressive parents every single day. And to some extent, of course, they can deal with, you know, hostility and aggression. You expect a parent to be a little angry and be frustrated with the situation that they're in. But in Ms. Price's case, this was really extreme. She, the aggression was so significantly affecting her ability to really make progress on her case plan. She, for example, with the domestic violence counseling, she didn't want to do that. She did it, but then she would continue contact with the abusers. I would say that while, you know, the hostility on its own.
Aren't the abusers the children's fathers?
Yes, Your Honor.
So wouldn't she necessarily have to have contact with them anyway as far as children? Or no, do they have separate visitation with the children?
Your Honor, I'm not exactly sure about that. I think that I can't exactly recall how they figured out that situation. I apologize. But in terms of...
Judge Schaefer's raising a good point. You know, if you don't have a protection order, if you don't, you know, don't have separate things all arranged, and, you know, it's one thing to be, like some of the cases we see, it's just a live-in boyfriend that has no connection other than their live-in boyfriend.
Your Honor, I'm not sure exactly how they
That's
set up
fine.
the visitation order. I apologize. And the second issue that the appellant raised was in regards to the abuse allegations. Now, some of the abuse allegations came in the form of the guardian ad litem's testimony that the children had told him that the abuse had taken place. In terms of that testimony, that is admissible hearsay. Ohio courts have ruled that the hearsay contained in a guardian ad litem's court-appointed investigator's report is admissible. In regards to any hearsay that was inadmissible, the hearsay did not rise to the level of plain error. The test for plain error is, but for the error, the outcome of the trial would have been clearly been otherwise. There were a lot of bases for the permanent custody trial. Those abuse allegations were mentioned in the judgment entry, but they were a small part of a 5-page judgment entry. I don't believe that they would have changed the outcome of the trial, that permanent custody would not have been granted had those abuse allegations not been testified to in court.
I think that it's difficult to minimize the impact, whether, it's a couple of sentences as opposed to several paragraphs or pages, but the impact of suggestion of sexual abuse, if it is reported by the GAL, and there are some cases, as Judge Carr was saying, where it's such a slam dunk because the children have been exposed to just horrific things, and mother is, continuing to use drugs, and there's no food in the home, and the children are walking around in the winter, without adequate clothing. This is not that case. So we have to evaluate the impact on the basis of what else is in the record.
Your Honor, I would say that if you were to take out those abuse allegations, just leave all the other bases for why permanent custody was granted, I would say there was plenty there to grant permanent custody. Mother really failed to correct most of the issues that led to the removal of the children. She didn't have consistent employment. She didn't have a home that was suitable for the children until, I think, right before permanent custody trial. She set up her house with some futons for the children. She continually had issues dealing with children's services, and that was really harming her progress on her case plan. Additionally, the children themselves are doing better in foster care. In regards to the child 3MP, she has significant behavioral issues. She's been diagnosed with attention deficit hyperactivity disorder, reactive attachment disorder, post-traumatic stress disorder, and mother stated at one point to a caseworker that she would take the child off the medication that she's currently on if she was back in her custody. Mother showed that she really could not deal with the significant special needs of that child. That child was the child that was placed in Guidestone, and her visitation with this child was extremely inconsistent. She missed the child's birthday, and at one point the child told the guardian ad litem that she was not ready to go home because she didn't want any more beatings. Both the other children, 2MP and 4AK, were also doing much better in foster home. 2MP, according to the GL, was doing well in the foster home. I believe he asked to be moved to a different foster home, but my understanding is that's pretty normal for a child to deal with some issues with foster care, that he was doing much better in foster care than he was under the custody of his mother. And then 4EK is young, only about 4 years old, and he had some speech issues and some issues with his eating habits, and I guess that's improved significantly since he went into foster care. In terms of the child's wishes, it was hard for the GAL to really discern what the youngest child wanted. But for all three minor children, the testimony at trial really proved that it would be in their best interest to be placed in foster care, and it would really further the goal of permanency, because mother showed over the life of this case that she would not be able to provide really a permanent and secure home for these children. And just to go back to the abuse allegations briefly, I know that the appellant argued that she did not receive sufficient notice of the abuse allegations. In the affidavit that was attached to the complaint that was filed by Lorraine County Children's Services, it stated specifically that the children have disclosed some very concerning events and situations that occurred while residing with mother. And in late April and early 2014, there have been 2 disclosures of sexual abuse made by 2 children, and these abuse allegations were currently being investigated. So the appellant did have notice of these allegations. The evidence presented at trial really clearly demonstrated that mother continuously and substantially failed to remedy the conditions that led to placement outside the home. While she did fulfill much of her case plan, she never really corrected the behaviors that led to the removal of the children. She really did treat the case plan as a checklist, and she never felt like she needed the help that was recommended to her. For example, despite attending anger management classes, her behavior really stayed the same, that she was still so angry and hostile towards children's services and other case provider or direct service providers that she worked with. Now, trial, really clear and convincing evidence was presented that the children could not be placed within the parents within a reasonable time, and the grant of permanent custody is in the children's best interest. The children have substantially improved in both behavior and development since being placed outside of the mother's home. And based on these reasons, Lorraine County Children's Services respectfully request that the trial court's grant of permanent custody be affirmed.
Thank you.
Thank you, Your Honor.
You have around 3 minutes remaining.
With regard to the argument that the hearsay contained in the GAL report was can somehow be still relied upon by the court, I would disagree. And in fact, the case cited by appellee in their brief, In Re AL out of the 6th Appellate District, simply says that a GAL report containing hearsay can still be considered by the court. It is not evidence. And the reason why it can still be considered by the court is the appellate court's trust that the trial court will not rely on inadmissible hearsay. So I don't think that hearsay contained within the GAL report, that the GAL testimony somehow cures it of its hearsay characteristics, and the trial court still cannot rely upon it in inadmissible hearsay. The statement that mother treated the case plan as a checklist and made various statements to the caseworker that she really didn't need this and really didn't need that. At trial, she testified as to what she learned through all of these exercises. She testified that she had learned that she needed some help, that she had been trying to do too much. What she has said in isolated instances to a caseworker at some point during the life of the case, especially when we know that her and the caseworker did not get along, I don't think that that comports with fundamental fairness to take that kind of statement. We don't know when that was said. We don't know if that was said the day after they filed for permanent custody. We don't know what was going on. We don't know the context. The trial court needs to rely on what the trial court determines based on the evidence before it. So, mother's actual actions and going through the components of her case plan, I think speaks louder than any kind of isolated comments she may have made to the caseworker at some point during the case. The allegation that she somehow did not show study employment really confuses the issue as to who mother was bound to prove employment to. Children's Services kept stating, we were never able to verify employment by mother, but the GAL was able to verify employment. Mother came to trial with pay stub after pay stub after pay stub presented to the trial court demonstrating her study employment. Really, you can't still have any doubt that mother was not steadily employed, with some brief breaks that she explained in the trial court. And even then, if she weren't employed, she showed that her periods of non-employment, she was able to be on public benefits. There was never any issue as to her ability to be able to care for the basic needs of the children. And in fact, the caseworkers, I believe the transcript shows that they conceded that the house was okay, that the rooms were set up for the children to return. And so some of these arguments on appeal seem to really contradict what the caseworkers themselves conceded at trial.
But is there a sense in which, and I know I've been harping on this, the fact that the trial court and of course the agency are focused on, she didn't get along with us, she was difficult. But looking on the flip side of that, isn't there a sense in which her inability to deal with the agency might give us some insight in how she's going to be able to parent in other situations that arise where there's a conflict with a provider and she can't get over her prior experience? Isn't that something that the trial court was not only permitted but required to consider?
Yes, Your Honor, I would agree that there is some aspect of that consideration that the trial court needs to take under advisement. But just to respond to that, really in this case you have to look at the period of time where she had to demonstrate some of these changes. She had 6 months to demonstrate, not only work through all of her issues with the agency, but then to not get angry when one of her children wasn't transported for a visit, which I think proves that she really loved her children. She wanted to visit with her child. And the fact that...
And you need to wrap up.
Okay. And you also need to look at what reasonable efforts the agency made. When Mother could not get along with Bob Reitman, why wasn't there another parent mentor suggested? When she was told that her parenting class...
I'm sorry, I can't let you talk forever.
Thank you. Thank you, Your Honor.
Okay. We will take the matter under advisement, and a written opinion will be sent to both sides, and you also can look on our website. Thank you so much.
Thank you.